So Russell Brand's hinted at something to do with a leak of information, probably likely from Assange's lawyers or his family, because they're in contact with Brand, because Brand interviewed them, about maybe that he might be able to be released, but he's got to enter a plea or something. Seems quite unusual, that. I've heard representations from American judges, like, serving judges in America. This is like a profession, so, you can't say that, well, unless you think the standard in America is terrible, but these people on YouTube are meant to be like, a proper judge, and they've given effectively their own representation. You could say their own appeal to the British courts. I don't know if they've submitted it officially through the Judicial Conduct Investigations Act. Why did I say Act? The Judicial Conduct Investigations Office. They probably have. I think that case has likely had the most number of complaints in a long time. Probably not the most number of complaints in history, but it's probably up there. I reckon. I've got a few complaints, and looking at the number of complaints that they've had between when I submit one complaint and another complaint, there was a lot. So I think that they've had at least a few hundred complaints, I think. So I don't know what they're if they're all against Johnson, but you're not really, the complaint has to be against the judge. The complaint can't be, you're not supposed to be doing the legal representation unless the judge, well, the thing is, I've actually complained that I've actually already, someone else, this is the thing, I've already done a petition, which you got a legal right to do. I don't have to be Assange, and I don't have to be his lawyers to do that. And no one else had submitted one. So therefore, and I knew the Petitions Committee would likely reject it, so I thought I'm going to complain about the Petitions Committee. I registered one on Australian Parliament, but then the main point of, it's about a petition, so I can talk about it. I've started to realise, maybe I shouldn't be uploading these videos if it's JCOI, but I don't publish the actual complaint that I made. And at the end of the day, you can grab evidence from anywhere and submit it in a case. There's a lot of people talking about the Assange case anyway. If it's for the petition, then you're supposed to get people to sign it. That's the point. I think that's a good example of the avenue of complaint. Anyway, the fact that people are talking about it is evidence that it's in the public interest and realm. I don't know why they put interested parties in the representation either. But anyway, Russell Brand's been going on about this. He's done a poll, actually. It only appeared as a question in the poll, but he's hinting at that they might be going to release him or something like that. But if he gets a plea. And I'm like, well, you don't have to give a plea if you want a resolution from Parliament. You don't really enter a plea because other people, like a jury, are effectively, if you could have a referendum on Assange, and that means that the people would vote on it. Does that mean that he'd get a plea? That's an interesting concept. But my bit, to be honest, the basis that I put, what I decided to, the basis that I settled on, I think, at the end of my argument was that I realised that the thing is that Anthony Albanese has already said that, he issued a statement that he thinks Assange should be released. So that's the Prime Minister of Australia. And if Australian Parliament can get things put through, an order's made, the thing is that this is what I figured out. In my opinion, I think that the 1688 Bill of Rights and Magna Carta are actually it is the same act or the same law, not similar. It is the act and the law in effect in two countries together. I don't really think that they've just made their own and copied it, because, well, Australia is a colony, wasn't it? And it was operating under the authority of, a king. So there was some that Charles Wells? There was a guest on Vobe's channel, that Charles Wells, and he's been into court. He's won court cases. This is not like some of the other guests who have just been, faffing or playing around with it. This is like that guy from Tamworth and the Neaton area who went into court and won, like illegal corruption charges against the police and so forth. This guy in Canada, he actually goes into court and he wins on certain legal basis that the Canadian Constitution is flawed or in error and not enforceable, and then the police don't go after him anymore for fines. And apparently, he's just he's just being very, very confident and successful in the courts, and not let them mess him around. And he comes out of it. So it's not like a lot of tosh. It's not like a blag or a bluff. Apparently, the Canadian Constitution is flawed. I don't know where it stands. I don't know where that stands with the rest of the government and with the Prime Minister, and the political parties there. But there's something to do with the basis of the foundation of Canada, where it's kind of like he sees it more as an enterprise and kind of joke, like comedy sort of country, which is quite interesting, really. But it must be. I don't really know what he's going to do with it, because I know that apparently they can't fine him on this legal technicality. They can't issue any fines to him, and I know he's definitely won, and they just leave him alone. But how does that stand in the entire country's reputation? How can... Surely people in Canada knows about it, and they just continue just ignoring it, like they do in England over certain things that we call them out on. I don't know. I could probably look into it. So for Australia, as that Charles Wells guy looked at the same basis for Canada for Australia, but there's... If Charles definitely has... those acts require a king. Well, they've got... It's a leader of the Commonwealth still. It's to do... I think it's to do with Charles being Queen's Commonwealth and all that. It's to do with the Commonwealth and Australia being part of it, and Charles having he must have a judicial role through the Commonwealth somehow. And therefore, it's to do with the rights of Australians still being subjects of the royal family in the monarch through Australian Commonwealth membership and through their foundations, where I think of Magna Carta, and I think it's because Charles legally can be sort of seen, still legally regarded as king, sort of Australians, even though they've got a prime minister. I don't think they have a House of Lords like we do over here, but this is why I said to the Judicial Conduct Office they need to look into it, But I don't... well, surely Albanese, the Australian Parliament can get things signed off by King Charles, effectively. So I think that means that if Albanese wants Assange released, he can petition the king, or even make an order through the Australian Parliament and get it passed through the House of Lords in England because Charles is in there. That's the way that I'd see it. But they might not want to. But therefore, we have got the right to petition the House of Lords as well as Albanese. But if Albanese has already passed, if Albanese can and has put Assange's, that he wants him released through Australian Parliament, then it's gone through that phase, hasn't it, in a way, that there could be some technology. He can do it. I mean, I'm not saying he has done it, but he's gestured that, he's close. He has gestured that he's moving towards that, or he begs to move in that direction, so to say. So, if that is the case, then it's not really within the High Court, is it? It's not a High Court's affair anymore. And the thing with America is it's got its own constitution, and although they've got an interested party and they want him extradited, the thing with America is this, right? They don't want criminals there, ironically. They're turning away all these people coming in through that border that they're trying to stop in Mexico, right? And if they've got a criminal record, they get turned away, right? I can't go to America. I got convicted of dangerous driving, which is ironic, even though the fact that it was legal to prosecute me. So, on that basis, they don't want criminals there. They're keeping criminals, if you've got a criminal record, then, stay away from America. So why do they want Assange over there? He's Australian. Why would they want him into America? Just so they can put him over their knee and smack his bottom, or, whatever. But they don't want criminals. They don't even want to smack the bottoms of people who are criminals who are coming in through the border. So why do they want to, but the whole thing is a setup anyway. It's like global propaganda. I don't even know where they pulled the Assange story from at the date they claim they did. It smells of kind of like deep, Assange, Rupert Murdoch, Australian media mogul, American military leaks. The whole thing is, it's like Neighbours and Home and Away. It's like, I don't know how they framed it to have happened at the time they did and so forth, but it's been captured and framed as and presented how it is. And, if you want to ask how, well, you might as well just ask how the Twin Towers or Madeleine McCann, or, that train crash where the signal failed and 150 people died in India. Same thing, it's one of these out there terrorist attacks that we can't prove. But the whole Assange thing, the leak came from someone else, and the footage is not even, the footage is questionable anyway. Like, it's acted. Did it even really happen? Is the video clip even a forgery, a leaked forgery anyway? It's just all bollocks. The whole thing is bullshit. And then, is Assange himself a scapegoat to intimidate and terrorise all of the press from all governments? It really is an enigma of an affair. Well, anyway, so I decided, seeing that I've been going on and on about these special legal processes, I wondered what happens, with Lord Hanningfield. The fact is that Jeremy Johnson, he did the Lord Hanningfield representation has been published. It's available on the internet. Anyone can get it. It's called Representations of the House of Lords. Observations. It's a representation called Observations on behalf of the House of Lords by Jeremy Johnson, KC, now QC. So anyone can get it. It's on the internet, available to anyone. And I thought that, seeing that I've been looking into this Corrupt and Legal Practices Prevention Act, I didn't actually know about what the plea part of it is, because I've been focusing on those like election petition part of it. It doesn't have to be election petition. An election petition can be through the courts, but I think that if it's one to Parliament, I think it's because of the authority of Parliament. It has to be higher up in like High Court or whatever. But anyway, so interesting. This is quite a long book. It is a proper book. It's got a black cover with gold writing, but ironically, the word plea only appears 5 times in the whole book. Look. Shall we see how many times the word indemnity appears? Wow, the word indemnity appears 18 times. Whoa! The word petition appears 293 times. Excuse. $51 times. Prosecutor 33 times. Criminal law, conveyance, deeds, contracts, constitutional law. All right. Constitutional law, Broom's constitutional law, viewed in relation to common law and exemplified by cases. Might check that up. I think that's a book. It's a reference book, innit? Worth reading that. Article clerks, bills of exchange, checks, chooses in action, common law, company law, constitutional law, criminal law. No, the word plea does not appear in the constitutional law or common law. You'd have thought it would appear in that. Pleading. Evidence and practice in criminal cases. Corruption and Good Practice Prevention Acts. Although an election is prior in time to an election petition, well, that would also go for a petition as well. A petition would be prior in time to a prosecution against a petition, if you could have one. Obviously not if it's a civil case, but what I'm tempted to want to do with this book is replace the word election for petition. And then you get a very interesting effect, because it's only one word change, and then it says a petition. I like that it solves a problem. If you get this book and change the word election to petition, right? So then it goes a petition, right? Then everything makes complete and perfect sense of complete and utter clarity, minus the tumultuous petitioning act. It would almost be like the perfect companion for the tumultuous petitioning act if we still had it, but we don't. it's like the most clarified revelation that could be possible, that we seem to be missing. Even the wording, the worst part of it, well, not the worst part of it, but the best part of it is that the creative language and poetic skills of the writer, you don't get books like this anymore. People don't write books like this anymore. It's like movies, right? Like when a lot of people are saying like they don't make movies like they used to, like they don't make amazing films anymore, like brilliant, clever, amazing films. Like the standard's gone through the bottom of the floor, and it's all like effects and like fancy graphics and CGI and so forth. But there's not like a proper decent script or a decent story. It's like that. Like the skill and articulation of which this book is written, in its choice of language and words, is like puts Russell Brand's dictionary literally out of commission. It's like this book is written by a very, very intelligent and clever person, and if you change that word election to petition, so then when you're reading through it, a petition, and then the gestures, references, and innuendos, and the intelligence of it, the weight of intelligence of the book as directions and clarification of all surrounding matters, all matters that are to be considered, contemplated, and given importance in procedures, is without doubt, it's just, we're missing this kind of intelligence at the moment. Anyway, although an election petition prior to an election petition is very desirable, it's very desirable that those who are carrying on an election contest should do so with a clear view before them of what would happen if the election in question should afterwards form the subject of an election petition. And we therefore propose first to consider the cause and effect of an election petition under these acts. And in our next chapter, to show how an election contest may so be carried on as to avoid any unpleasant consequences in the event of a subsequent election petition being brought under these acts. So you actually have to, I think you have to wait until it's finished till you do it. I don't think you can do it halfway through. Now, I've raised a couple of complaints with the election commission and to JCOI. So maybe I did it too early, but I suppose if you report it, maybe they can wait till afterwards. So maybe that's why there hasn't been any action yet on my complaints, unless they completely disregard them. Maybe you have to wait until it's over. But that isn't even the word plea, it's pleasant anyway. And then again, I've got plenty unpleasant consequences going on. A lot of people have got unpleasant consequences going on because they've been obstructed from carrying out their campaign work. Are we going to get another? Here we go. Pleasure. Plea Sure. Oh yeah, look, Plea Sure. Do you know, I never thought of that before. How interesting is that? Plea Sure. Pleasure. Plea Sure. Well, you're not going to be sure of a plea if you ain't got one, have you? Or if it's illegal to be prosecuted, because you won't be having a plea, will you? Like me, when I went with Watson, I wasn't putting a plea in because I was putting down the basis of my rights, which I already knew what the basis of the rights were. Well, I knew enough. I knew enough about the basis of the rights. In fact, to be honest, I think I'd done all the. I got it all fleshed out in common law anyway. I'm like, it's all weeded out in common law, and I'm like, you know, it's weeded out through Criminal Law Act and through town and country planning. It's all over the place in bits and bats where when it's usually relevant, even in criminal damage. And I don't know why the police act like they're fully retarded when it comes to the Criminal Law Act, because when you superimpose the Criminal Law Act, Plea Sure, pleasure. How is there any pleasure in a plea, particularly if you're going through a process which is not really very pleasing? It's displeasing. Idleness and drunkenness and avarice, nor can he follow his own pleasure as the manager of another business might do with regard to getting rid of the undesirables, for he must, whenever he fairly and properly may do so, consider the popularity of his candidate and of his party. Oh, well, that's Rees-Mogg, isn't it? That's Rees-Mogg's pleasure. This is like Rees-Mogg's pleasure on GB News, isn't it? Rees-Mogg's pleasure on GB News. I still haven't actually established whether or not they enter a plea for corrupt and illegal practices. I think someone reports corrupt and illegal practices, right? From what I gather, and there's election petition, you can have corrupt and illegal practices without an election petition, because there are other... Well, really, all of the corrupt, you know, all the offences like, you know, fraud and so forth can be brought through corrupt and legal practices, I think, besides just being a criminal offence. I think the novelty with that civil proceeding with the presence of a prosecutor is if the some of the witnesses can't be prosecuted, or if they've got privileges. I think that's the point, because if it's illegal for them to be prosecuted, then it's not a prosecution, is it? If you don't turn up in criminal proceedings, right, then the prosecutor can't prosecute you illegally and then be putting themselves in jeopardy of law, so to say. Oh, that was quite a good explanation, really. If they're in a civil hearing, they're there to establish the truth and facts on a matter. Although I think in civil proceedings you can have criminal matters arise in it. So I think like, you know, if someone complains about something illegal or being done wrong, I think they try it through a civil case and say, yeah, this has been done wrong, and you know, and what happened, what should be done to correct it. In a way, it was a little bit like when I said about Gail Bradbrook. I kind of said before I'd read this book, I'm like, well, you know, maybe like it has to be civil, because like if she can't be prosecuted, but if the claimant claims that they've had the window broken and someone owes them money, then they can go to the court and say to Gail Bradbrook, you owe me some money. But that's not a prosecution. But can she be liable to be civil proceeding? But the thing is, the window's insured, so it's insured for third party. So they're going to get the money back from the insurance anyway. So they don't need to take the Extinction Rebellion to civil court. There's no need, because they're already covered with insurance, although they might lose their, you know, a deposit or whatever it is. Maybe they could like claim for that or whatever. But there's something in that. Look at this, it's the pleasure of Mogg, isn't it? Nor can he follow his own pleasure as the manager of another business might do with regard to getting rid of undesirables, for he must, whenever he fairly and properly may do so consider the popularity of his candidate and that of his party. Well, you can't have Mogg can't be popular if he loses his vote. The thing is, I don't think Mogg's entered a plea, is he? He's been investigated by Ofcom, right? But he hasn't entered a plea. Mogg's been investigated by Ofcom, and they said that he did do wrong, but he hasn't. They think that he's done wrong, but that's not a trial, is it? And that's not the Privileges Committee investigating it, surely. What's the point in having Ofcom if... Just a minute. There's another thing that goes over the top of my head now. If Mogg's done something wrong and he's an MP, or if someone's accused him of doing something wrong, why didn't they just report him straight to the Privileges Committee? Or are the Privileges Committee too busy with their other MPs being naughty, not in connection with television, so they refer it to Ofcom almost like a subcommittee or something? It's almost like the Advertising Standards Agency don't touch political things, but that's a lie, because there are certain obligations. If they are governing advertisements, then there are certain things you can do with adverts and certain things you can't do, and they're not wanting to act. In most of the political things, they're presuming that they can't do anything or there's not anything to be done. But there are some things that has to be done because it's an advert, and actually the Advertising Standards Agency authority do have to do certain things, particularly when something actually has got a legal enforcement on it, and it is an advert, that the ASA are refusing to act in certain things. So all these agencies that are non-departmental government agencies are kind of, what actually is going on? Are they meant to be the ones who then... Is it almost like the postmasters and the post office have got their own prosecution departments, or what? And at the end of the day, if it's Rees Mogg, then he's got to go to the High Court anyway, or to the Supreme Court or whatever. But anyway, I think I'm just kind of like skirting around the subject now. I don't even think it says the word plea in here. Oh, look, here we go. This is the first appearance of the word plea by itself. So the first appearance is only in citation, and then it's the word in unpleasant, and then it is the word in pleasure. What section is this? General policy. Intermeddling in the suit of another, such as would support an action for maintenance, and whether a plea of common interest with the nominal petitioners would not be successful on defendant's part. In second place, it is impossible to obtain discovery which would be essential to the success of such a suit, because maintenance is a crime and everyone who knew anything of the maintenance would be protected from giving evidence. Second reason might be obtained by abolishing obsolete indictment from mainstream. Parliamentary election, but this pro would become the petitioner, not a mere dummy under cover of whose poverty and real and substantial attackers shelter themselves. It is notorious that rich men and rich associations have been behind the nominal petitioners in several of the cases. These find that 100,000 that must be deposited, this indeed a mere fraction of the cost of answering such charges. The successful respondent may recover. For the rest, he has a judgment against a man of straw. Hey, look, it talks about men of straw as well. It's true. This is what Verbs is talking about in his videos when all the courts are saying that they're talking a load of nonsense, but he actually refers to the man of straw in here. It's an actual proper thing. Should there not be some means of reaching the real maintainer of the suit? Perhaps an action at common law for maintenance may be suggested as the remedy, but in the first place it is at least doubtful whether paying the expenses of an election petition would be held to be an officious intermeddling. Shouldn't pay the expenses. Elections ought to be free, so surely election petitions ought to be free as well. In the suit of another, such as would support an action for maintenance and whether a plea of common interest with the nominal petitioners would not be successful. Well, so the thing is, well, I think that the subject is the subject, isn't it? So just a minute, isn't the petition itself? The actual petition itself is a plea of persons, isn't it? Surely. Because if in Baswick and Burton cases, the wives are petitioning for the release of their husbands to the Long Parliament, to John Pym and company. So that is a plea, isn't it? If the wives are pleading for the release of their husbands, so whether he's guilty or not, he was already found guilty. It's like it's asking. Well, I guess in a way, the jury are, once the jury decide that they don't want the, like I guess in Ian Bray case, the jury are pleading to the judge, really, aren't they? Or so like a consensual thing, isn't it, among a group? Was I police side and Crown side disputes? Why do they call the police? They used to refer. Someone said they refer to the police side as disputes between Party A and Party B. Police side and Crown side with the King's Bench. When there's submitting a grievance to the Crown, he was saying that police side was to do with disputes between Party A and Party B, but I don't know why. I don't know if I think that the Baswick and Burton's wives were making a plea to the Parliament through the petition and the other people, and possibly even to the wider public, which includes the jury. It's like a third. It's like that's like a third party plea, isn't it? It's like a plea from another party. It's like a third party plea almost. The thing when you're being prosecuted is that you're answering to the Crown. It's usually brought by the Crown. When they were doing all those private, but what about those common informers? We've got a common informer giving evidence to courts on persons, accusing them of something, and then they've got to defend it, and then they walk off with the money. That's kind of like, it's a prosecution, but it's between like party A and party B, but it's like on law breaking, on, it's like you broke the law, not like, civil dispute. That whole, when you split up with if you split up with someone and they've got your stuff, this is the thing, what I always find ridiculous, at what point, if a woman has got your things, right, what is the difference between prosecuting her for theft or taking her to court and saying, right, I'll have half the things, and then the judge agreeing that they are your things, there is some technicalities in this to do with intentions and, but how did they intend to, if they've got the stuff, then they intended to take them, didn't they? What if they don't belong to them? Well, who decides that? Well, if you already decided it, that person doesn't agree. Well, if you took them and you got you might be claiming a right. You might be claiming that you got the right to those things. I think that if you're the wife, right, and you've got all your husband's stuff, I think it's like I think they've got like, oh, this is my stuff. I've got the right to these, a right and a privilege to have them. I think that's it. And then if the judge decides if they are hers or not, or who has, who's entitled to what, and then once that has been established, if challenged in law, then she, if she doesn't give them over, then she's stealing them. But until that point, I think she's got to claim that, oh, these are my things, who says they're yours and mine. So, like, I think that if you go into a pub and steal someone's wallet or jacket, it's like, I think it's established that it's the other person's jacket. So, like, it's like, otherwise, because unless you're going to the court, and you say if you stole someone's jacket and go into the court and you've been prosecuted for theft, where you say, this is my jacket, it's my jacket, you say, oh, I didn't steal it, it's mine, but are you pleading not guilty then? Or is there's no charge, there's no offence, This is the thing. You say, if it were your jacket, then you haven't stolen it, have you? But are you putting in a defence that you didn't steal a jacket? Or if it was yours and you had the receipts to it, then, do you have to enter a plea? It's like in the Criminal Damage Act, doesn't it say, right, it shall not be construed as a defence against a charge if you're having a right privilege or interest. Well, if it's your jacket, you got the privilege of having it, haven't you? So, there's... it's not to be construed as a defence, though, against a charge. So at that point, I think that you're gonna. I think that under the criminal procedure rules, or recognising the rights of another individual, it's like you got like, if you're claiming that it's my jacket, I think that you're claiming that you've got the right to have the jacket and therefore you didn't steal it and you're not a criminal and you're not answering to a criminal charge. I think at that point, you're under the overriding objectives. If you claiming a right and you've got to recognise someone's right, I think that if you show the prosecution, like, receipt of ownership or like a photograph that you were wearing the jacket or whatever, and it's within reason to show that it's yours, then I don't think that they can charge you with the offence of stealing it, because it could be supposed that it's your jacket. And at that point, if you've got Party A and Party B who both claim that it's their jacket, aren't you there in a civil dispute against Party A and Party B that, like, whose jacket is it? Like, if you split up with your wife, like, whose sofa is it? Is this my sofa or yours? It's something like that, something around that I think... But, I mean, the police wouldn't entertain that. They wouldn't give a monkeys about this kind of detail. I mean, they're just like a blunt instrument, aren't they? They just, like, chuck the Criminal Damage Act at it and, like, jumping in a diving board into a swimming pool. Woohoo! Like, police guy, like, he likes his criminal damage charges. He's like, you know, strip his uniform off and down to his boxer shorts and just jump into a, you know, belly flop into a swimming pool with a criminal damage charge. Bang! He ends up with a big red belly. You know, he's, woohoo! Almost like, you know, on Point Break when they've got the Angelo guy when he's blindfolded fetching bricks off the bottom of the swimming pool, isn't it? When he's talking to Utah, like blindfolded, you know. It's like the police most of the time with the criminal damage charges. They're just like a blunt instrument with them, basically. Anyway, what's the last? Wow! It's another citation. Viz to maximum punishment of 7 years penal servitude and see Archibald's criminal pleadings. Wow, so it's not really got the word for entering a plea in this. It's only in there once. In the whether a plea of common interest with the nominal petitioners would not be successful on the defendant's part.